Hello everyone and welcome to this informational video. Today we're going to do power of attorney. With me I have a special guest who is, I consider, well knowledgeable in this topic. Let me introduce Mr. Atif Nanji.
Thanks, Arnie. It's good to be back.
Nice to have you back again doing these interviews. I'm having fun, by the way. Very intense, but I'm having fun. I'm learning, and that's the key part of this. So, Atif, let's get started. Power of attorney. Now, the very first question that I have is, the very first word throws me. Enduring power of attorney. We're so used to saying power of attorney. Why do we add the word enduring to this?
Enduring was added kind of in 2011 when they revamped the legislation. Most powers of attorney are enduring. That's kind of the whole point of power of attorney. All enduring means is that the authority continues after you lose capacity. If it's not enduring, or if it doesn't contain an enduring clause, then the authority actually ceases upon a loss of capacity, which for most people kind of defeats the purpose of doing the power of attorney.
Okay, that's a good answer. I was thrown by that because throughout all my life it was power of attorney or POA, yeah. Never enduring, but that's good. That's good. All right, now we talked in the previous video doing comparisons, so I'm going to do another comparison. This time it's going to be, what is the difference between an enduring power of attorney and a will?
So a will is strictly for after you pass away, whereas a power of attorney is strictly for while you're alive.
Okay, there's a definite difference there. That's black and white, you might say.
Yeah.
All right. All right, next question. What is the difference between an enduring power of attorney and a representation agreement? Now, we talked about health representation agreement.
Yeah, very good question, because a lot of people do get those things mixed up. So a power of attorney is strictly for legal and financial matters, and a representation agreement is strictly for health and personal care matters. Except for a particular type of representation agreement in Section 7, which can include financial powers. However, that type of representation agreement, it's designed more for people that have already suffered a loss of capacity. So the powers granted, at least financially, are not as great as you would find in a power of attorney.
Interesting. So financial to health.
Right.
Okay, good point. And I think that's a very important point to note, because a lot of people will only get a power of attorney, but they won't get a health representation.
Yeah, that's true.
And they should have both.
Ideally, yes.
Yes, ideally. That's the key word, isn't it? All right. All right, so now my next question is, who should have an enduring power of attorney? Should it be like an older person, a younger person, someone who works out of town, somebody has a dangerous job? Like, how would you answer that question?
So the easiest way to answer is that anybody over the age of 19 should ideally have a power of attorney. I think that there are certain cases where it's probably more important or imperative than others, such as some of the examples you mentioned. So if somebody's traveling a lot for work or pleasure, if somebody's working a dangerous job, if someone's getting elderly and there's a chance they may at some point lose capacity or the ability to manage their own finances, those would be more pressing reasons to get it done. Or if you own property as well, it's quite important. So yeah, I would say in those situations it's very important. However, I mean, honestly, it's hard to argue with the statement that everybody should have one.
Right, right. Yeah. Some people more so than others.
Right.
Yeah. I know in a conversation we talked about the workers who go out to these camps. It's a one road in, one road out, and transportation is provided, so they are there for 3 to 6 months. Their car insurance comes due, they've got to pay bills, so that person could be a younger person, could be an older person. That type of person, okay, would definitely fall into this category of having a POA.
Yeah, and actually, I've had quite a few clients come in for that reason as well. When they work up in camps and they need to make sure someone can manage things while they're away.
Right.
I think communication is getting better in those camps, but it's still probably easier for them to have someone else here locally do it for them.
Yeah, exactly. Now, when we talked about the health representation, we used the word choosing your representative. In the power of attorney, do we use the word attorney, like choosing your attorney? Because the word attorney to me is like on TV, we're watching Matlock.
Yeah.
But in this case, attorney has a different meaning, does it not?
Yeah, so attorney is, we use it as the term for your representative, as you would in the representation agreement, but this time in the power of attorney. So it's just the term for the person that you're appointing to manage your affairs.
Okay, all right. So just a legal definition.
Yeah, pretty
Right?
much, yeah.
A representative attorney, like not to be associated with the Matlock.
Yeah, that's right.
Character. All right. Now, can a person who is putting together a POA, power of attorney, or enduring power of attorney is what I should say, can they assign or appoint more than one attorney?
Yeah, in fact, we usually encourage it. So when you're doing a power of attorney, you can appoint one or more people, and you can decide whether they are going to act, whether those people are going to act jointly, whether they can act separately in the kind of a separate but equal fashion, or whether they act successively, where you have a primary attorney and then an alternate if the primary is unable to act for you.
Sure. Okay. Can you assign an attorney who lives out of the province?
You can, but ideally you'd want to try to find someone that's going to be available to act for you, and ideally someone that lives closer. But
Sure.
For many people, for their kids are living in different provinces, everybody's scattered about. So we appoint kids from our attorneys that live in other provinces all the time.
Okay.
I think the key thing is just making sure that they will be available to act when necessary.
Sure. Okay. That's good. Now, this next question is a little bit more challenging to me, only because I don't know all the answers. That's why I'm asking you these questions. But this is a four-part answer, I believe. It's like the types of power of attorney. I've got listed here power of attorney, enduring power of attorney, springing power of attorney, limited or restricted power of attorney. Now, the first two make sense. The last two confuse me. Can you clarify those for me?
For sure, yeah. So starting with the first two. So when we say power of attorney, most of the time, even if we don't say enduring, usually we're referring to an enduring power of attorney. However, a non-enduring power of attorney would be a power of attorney that ceases to be valid upon the adult's loss of capacity. An enduring power of attorney, on the other hand, the authority would continue beyond a loss of capacity. So now to go to the last two. So a springing power of attorney is probably what many people think about when they're thinking about power of attorney. And that is a power of attorney that comes into effect only upon a loss of capacity.
Okay.
I mean, technically a springing power of attorney can come into effect, the triggering event can be anything you want it to be, but most often when you're doing that type of power of attorney, it's going to be a loss of capacity used
Sure.
as the trigger.
Okay.
And the last one, a restricted or limited power of attorney, simply means that it's power of attorney, but only to deal with very particular matters, or restricted to particular matters, or maybe they can deal with everything except something.
Sure.
So, for example, you could grant a power of attorney where your attorney can manage all of your finances. However, they're not allowed to touch a particular investment. Or alternatively, you can do a power of attorney that's limited only to deal with a particular asset, like a sale of a property, for example.
Okay. Oh, well. Okay. That clarifies it for me. Thank you.
Good.
Because I was really, I see the word springing, and I'm thinking like on a trampoline or something like.
That would be a lot more fun.
Yeah, it would be a lot more fun, but definitely not in the same topic realm. Okay, now we've touched on this one on the health representation, and of course we're going to touch on it again. What is capacity, and how is it determined?
So capacity, we're referring to legal capacity, or the capacity to sign legal documents. In this case, we're talking about power of attorney, and luckily the Power of Attorney Act for BC lays out the requirements for capacity.
Okay.
So I think there's 7 requirements total, but so mainly we want to make sure they understand what a power of attorney is, what it can be used for, that the significance of appointing the right attorney, and failure to do so could result in misuse of the power of attorney, which could result in a reduction of their finances. So making sure they understand all that. Also, they're able to revoke the power of attorney if necessary. But the one that's usually people struggle with the most when there is a potential capacity issue is being able to identify their assets and their approximate value. Even for people that don't have capacity issues, this can be a problem if they don't review their finances regularly.
Sure.
Or in the case of married couples, sometimes there's one spouse that's handling all the finances, the other one, doesn't really get involved very much, and that can be an issue when we're doing these interviews if they're not aware of these things.
And that's a good point, knowing how much your property is worth, or even your full name, for an example. That determines your mental capability to understand what you're facing at that moment.
Yeah, definitely asking about property and value, if there's any mortgages against it, where they bank, what types of accounts they have, approximately how much money they have.
Sure.
Same thing for investments. Those are, it's really key to make sure people are aware of those things before they grant someone else power of attorney.
Sure, yeah. You ever ask anybody like how many children you have and what are their names?
Yes, all the time. Actually, that's a standard question for me, because, yeah, I believe that helps me get a good a sense of a person's capacity. Is I ask them to name their kids, provide me their names and dates of birth or their age and approximately where they live.
Right.
And you'd be surprised how many people struggle even to do
Sure.
that. But that's a pretty good indicator for me that there could be some challenges there with regards to capacity. So I like to start with that. Jumping right into finances can be a little bit abrupt sometimes.
And personal.
Exactly. So I like to start with some other questions and kind of ease in there a little bit.
Right, yeah. You want to be their friend before you hit them with the financial stuff first.
I guess so, yeah.
Yeah, you want to go for coffee or...
Maybe not that far.
Yeah, exactly. All right, now, this is kind of an interesting question from my perspective. What happens if a person becomes incapable, but they do not have an enduring power of attorney?
Yeah, and that happens all the time. A lot of people will bring in their parents for power of attorney, and it's too late. They've already suffered from onset of dementia, or maybe they've had a very serious stroke, and we're not able to meet those capacity requirements. So one option can be the Section 7 representation agreement, which we spoke about at our last interview. That's a particular kind of document that's designed for people with diminished capacity, and it grants authority to make routine financial decisions. However, that's not always adequate, particularly if the adult owns property that the kids have to manage, because the representation agreement doesn't cover that property. So if that is, if there's property involved, then I would normally advise them to talk to a lawyer and seek something called a comitationship, which is a court order granted by the Supreme Court, which would, the applicant, assuming it's, let's say, one of the children, if they're successful, they'd basically become the guardian for their parent and able to do make all decisions on their behalf.
Sure. Okay. You're getting good at this, because I had that as my next 2 questions, about the Section 7 and the comitationship. You got to take up mind reading, there's good money in that, So I just want to go back to the Section 7. Is that part of the enduring power of attorney, or is that a separate document?
That's a separate document. It's actually, that's more of that's a creature of the Representation Agreement Act.
Okay.
Whereas power of attorney is governed by different legislation.
Okay. Okay. Good. Very, very good. Okay. All right. We're winding down on the questions here. They should be getting easier. At least from my perspective, they're getting easier. Changing or revoking an enduring power of attorney? Can you change one?
You can. Normally it involves simply revoking the old one and doing a new power of attorney, naming the people you now wish to act for you.
Okay.
Sometimes there can be some overlap, but yeah, basically, canceling the old one, doing a new one is the way to do it.
So if you did a change, that means you have to keep the old document. The new document kind of like coincides with the old document, but by revoking the original document, starting fresh, you only have one document to play with.
Yeah, I think it's a lot clearer and cleaner to do it that way.
Yeah, that makes sense. That really does. That does. Okay, now, how does an enduring power of attorney end?
It can end in many ways. It can end, upon the passing of the adult. So if you pass away, it can end if you revoke it. It can end if for some reason a comitationship is granted by the court. So it can end by court order. It can also end if all the attorneys resign. And I think there's a couple other ways as well, but those are the main ways we would see a power of attorney come to an end.
Okay. I just have to go back a little bit here, just because the question popped into my mind here. Commentateship, is that you mentioned, okay, that's appointed by or given by the court. Would you approach the court asking for this, or does the representative or the attorney have to ask the court for this?
They would need to ask the court for this, and usually they would need the help of a lawyer to make the application.
Okay.
It's quite a lengthy process, and it's quite expensive.
Okay.
Yeah. So that's why it's much better to get those documents like a power of attorney or representation agreement in place while you still have capacity. It's much more cost effective and much easier on the family.
Sure. I've only heard in my entire life one commentateship, and it didn't end well. They no sooner got that appointed by the court, and the person died. Almost a year's worth of effort to get that document.
Yeah.
And then they died, I think it was a week after, and then the will took over after that.
Yeah. I've heard a lot of our clients will come in because when you're named as a comité, you have to sign an annual report, do annual reporting to the Office of Public Guardian Trustee. So I think there's more reporting requirements, and it can be cumbersome.
Okay. All right. We're winding down. Last couple of questions, unless I think of something else. Now, we've touched on this on the health representation, and I'm sure it's the same, but I'd like to go over it again with you. What is undue influence?
Undue influence is anytime somebody's using a position of influence or power to coerce or pressure somebody into doing something they don't want to do, or that they wouldn't, do on their own. So an example might be, let's say a mother who depends on a child for rides to the doctor's office, maybe picking up groceries, maybe brings her medications. In some ways dependent on the child, and the child then uses that to try to convince the mom maybe to change her will and maybe give that child a larger share of the estate, or maybe make the child joint on a bank account or on the house or on their home or something like that.
Sure.
Those would be kind of the classic situations we would see. However, it can be anybody in a position of influence, and it usually has to do. And usually, the adult in those cases is usually somewhat vulnerable. Maybe there's mobility issues. They could have already had maybe a minor loss of capacity, so they're dependent on somebody else, and that makes them vulnerable to this type of thing.
All right. And that undue influence can come from other people other than family.
That's right. Yeah. So sometimes, in my just in my experience, I've seen it happen from caretakers. Like live-in caretakers. Sometimes neighbors. And occasionally friends, but usually I find it's usually children that are unfortunately, and sometimes grandkids, but usually it's the children.
Yeah, I can understand the child, sibling rivalry.
Yeah.
Yeah, the eldest thinks that they're entitled to everything,
Yeah.
and
And sometimes, I can kind of see, even though I have to guard against it, I can see sometimes where the child is coming from in situations where maybe that child is the only person helping their mom, and the other kids are maybe living somewhere else. So this child has been putting in a lot more time, and they feel like they deserve more. Unfortunately, that's just not the case,
Right.
But well, it really comes down to what mom or dad wants, not so
Right.
much what they think is right, the
Right.
child, but what mom and dad think is the right thing to do.
right, and keeping things equal is the best way to go, so that each child gets an equal share, even though one did a little bit more than another.
Yeah.
It just eliminates a lot of hassle in the end.
Yeah, and I think if a child is doing a lot more for mom or dad than the other kids, I think it's important. It's not always viable, but those kids should talk amongst themselves
Sure.
and try to come to an understanding and be like, okay, if I'm doing all this, if I'm putting in this effort, how are you guys going to feel if I get a little something back at the end? I think the family needs to talk more and have an understanding amongst themselves,
Sure.
rather than trying to sneak around their brothers or sisters' backs and trying to wiggle their way into the estate or onto the title of a home.
And
That's
that-
another big thing I see a lot.
And that does happen.
A lot. Yeah.
Yes, yeah. Yeah, most fights in families are probably over that.
Yeah.
Yeah. Okay, the last question, and let's hope it's the last one. All right. I just put down here process. What is involved? How do you get this started? How long does it take? Is this like a week-long event to happen? Is it a one-shot deal where you go into your office, you have your appointment, you go in, you go through all this? Explain the process.
Sure. So the process can vary depending on on the mobility of the adult. So if they're able to come to our office, the standard process would be to get it done in about 1 hour appointment. So they come in, we would interview them, and I would have to meet with them alone. I would take their instructions, make sure they meet the capacity requirements, and then we would prepare the document and have them sign, all within the span of an hour.
Right.
So that's the best way to do it, and that's only if they're able to come to our office. For some clients that are unable to leave their home, or maybe they're in the hospital, then we have to arrange an out-of-office visit. So in those situations, it gets done in 2 visits. So the first visit will be for me to meet with the adult and take their instructions and confirm capacity. And then there'll be a second visit for the signing. I usually try to get those done within 2 or 3 days, but depending on availability, sometimes it can stretch out over a week or 2.
Sure.
Yeah.
Wow. Is there an extra charge for you to go to like a care home or a hospital?
Yes, we do charge. We do have an out-of-office charge, and it's not cheap either. When we have to do 2 visits, which most of the time is required, it's the out-of-office charges are actually more than the power of attorney itself.
Wow.
So we certainly encourage people, if possible, to try to, if they want power of attorney or any of these documents, to try to come to our office to get them done.
Sure. Yeah. And there again, it depends on the scenario of the person that you're doing the document for.
Yeah, we understand if people, sometimes kids don't, or families don't think about this stuff ahead of time, and until mom or dad's in the hospital, and then, hey, we need to get this done. Right. And then all of a sudden there's a bit of a panic, and then I do explain to them the costs, and if they feel if it's important enough or urgent enough, then they agree.
Right. Yeah. I just thought of one question, another one.
Sure.
Why would I go to a notary to have a POA done as opposed to a lawyer?
I don't. If you're doing a specific kind of power of attorney, maybe for corporate matters, or you're going to be dividing up authority over different assets between different people, that might be where you want to get a lawyer involved. If it's going to be more of a complex document. But for most people, they're doing enduring powers of attorney or springing powers of attorney. or restricted powers of attorney, and those notaries can do that stuff.
Sure.
Yeah, it's pretty. The document itself is typically not very complicated.
Right.
It's that process of interviewing and confirming capacity and confirming there's no undue influence. That's really where that's really most of where our work takes place.
Okay. And that's the same with the health representation too.
Right.
Much easier to go through a notary and cheaper too.
Yes,
Yeah,
I like
yeah.
to think so.
I'm not calling you cheap, but you know.
Well, thanks for clarifying.
Yeah, exactly. Well, Adif, that's the last question. I got to say thank you for doing this interview with me. We're going to be doing another interview after this, the wills, and I'm really looking forward to that one. And I hope that you're looking forward to it as well. And I know I've studied a little bit, but I hope you've studied a lot, because I got a lot of questions to ask you on that one. But to end this video, Adif, I want to say thank you very much. I really appreciate you taking your time for doing this.
No problem. It's been a pleasure.
Awesome. Okay.